Good afternoon, everyone. This is a recording of a talk I gave at the German East Asia Conference on Company and Securities Law at the University of Tokyo in spring 2025. For some background, I am Timo Fest. As of October 2024, I am the new professor of Corporate and Capital Markets Law at FAU Erlangen-Nuremberg. Currently, my research focuses on corporations and capital markets law, and over the next 25 minutes, I will share with you a German perspective on the role of shareholders in the age of sustainability. Following the ratification of the Paris Agreement by the EU, the Commission presented an action plan in December 2019 called the European Green Deal. Its central aim is to transform the EU into a resource-efficient and competitive economy in which there are no net greenhouse gas emissions by 2050. There is consensus that this ambitious goal, if not already out of reach, can only be achieved by mobilizing companies, particularly the so-called carbon majors. The idea that all contracting parties to the Paris Agreement would cooperate and enact globally harmonized regulations, such as an effective global CO2 pricing mechanism, has proven to be an idealistic illusion. Therefore, the EU is currently pursuing what might be called the second or third best option, namely a comprehensive shift in how the financial system works, with the aim of reorienting private capital to more sustainable investments. To this end, the EU, based on the Action Plan Financing Sustainable Growth, has introduced detailed reporting and disclosure obligations in numerous legislative acts. These are intended to enable institutional investors to undertake more comprehensively informed investment decisions. Nearly all listed companies have responded to these measures by setting themselves science-based targets for reducing their greenhouse gas emissions up to and including net zero. To the extent that investors disagree with the transformation process undertaken, it is in keeping with the EU's capital market regulatory approach for them to divest their stake in a company and reinvest their capital elsewhere. Alternatively, investors may choose to take an active approach and seek to influence corporate management through their shareholder rights, known as sustainable shareholder activism. Due to the conviction that the impacts of climate change pose the greatest financial risk to the long-term value of assets, major asset managers have joined private initiatives such as ANSM, Net Zero Asset Managers, representing over $75 trillion in assets under management. Such initiatives call on the world's largest corporate greenhouse gas emitters to disclose a net zero transition plan and to let investors vote annually on progress against the plan. Among the signatories of ANSM is the Children's Investment Fund, TCI, which has gained notoriety for its aggressive sustainable shareholder activism. A 2020 breakthrough campaign targeted Spanish AENA, the world's leading airport management company, where TCI succeeded in establishing the first say on climate vote with a direct stake of less than 4%. At the AGM, TCI's proposal was approved with a 99% majority, mandating the board of directors to develop a climate action plan and to submit this plan for a vote at the 2021 AGM. The proposal gained overwhelming approval through the support of leading proxy advisors and asset managers like BlackRock, who had joined groups like Ensam. The number of similar shareholder proposals almost doubled from 2020 to 2021, and votes on climate transition plans have gained popularity since. While leading American asset managers signed on to climate initiatives, critics of these groups emerged, forming a vocal anti-ESG movement in the USA. The movement began with a focus on legislative changes, particularly in Republican-led states, to withdraw public funds from climate-aligned asset managers. Subsequently, anti-ESG shareholder proposals targeting US-listed companies more than quadrupled between 2021 and 2024. Beginning in 2023, the House Judiciary Committee, led by the Republican majority, started investigating major asset managers, claiming that their pro-ESG activities constitute a violation of US antitrust law. The latest development for pro-ESG investors has been a change to SEC reporting guidelines on beneficial ownership, expanding the obligation to file a more onerous Schedule 13D instead of Schedule 13G. Supposedly intended to increase transparency for investors by showing the manager's intentions, this change is specifically targeted at ESG investors to increase the burden of any public ESG commitment. The implications of the US anti-ESG movement are significant for sustainability investors around the globe. Leading asset managers like BlackRock left Ensam and other climate action groups, and influential proxy advisors no longer endorse annual advisory climate votes. Starting in 2027, the EU will require large companies to adopt a climate transformation plan, CTP, through legislation in its member states. The preparation of these plans, which numerous German companies have already developed as part of their medium and long-term business policies, is a task assigned to the management board. Since neither the supervisory board nor the general meeting or individual shareholders possess any authority to issue directives, the management board is charged with drafting and adopting a CTP at its own discretion. In doing so, it must balance the interests of shareholders, employees, and the common good, particularly regarding climate and environmental protection. As soon as it becomes public that the board is engaged in this process, activist shareholders begin seeking ways to exert influence on the management board. Campaigns typically start through public board engagement by activists of their vision for the company's transformation. If there is no positive board reaction, activists continue by seeking confidential discussions. While the German Stock Corporation Act, GSCA, does not explicitly provide a shareholder right to require the board to engage in such a discussion, there is consensus that concerning significant measures, such as the drafting of the CTP, the board is obliged to at least ascertain the views of major shareholders. In informal engagements, activist shareholders can demand not only that the board does not finalize the CTP on its own, but that a draft should be submitted to shareholders for ratification. The board is under no legal obligation to accede to such requests or to allow for a shareholder vote, not even for measures of outstanding significance for the company. Generally, The board uses its discretion to decide on matters itself, arguing that doing so forgoes the delay in resolving matters associated with convening an AGM, as well as the external impression of a decision-shy board. Regarding CTPs, these arguments carry less weight. Firstly, the implied changes in the company would occur over several years, so there is no immediate time pressure. And secondly, many stakeholders publicly demand involvement of the AGM on this issue, which would likely project the image of an engaged board that welcomes input. Nevertheless, no German stock corporation has let its AGM decide on a CTP. This statement requires a more detailed explanation. According to Section 119, paragraph 2 GSCA, the term decision is of particular importance. If the board requests a shareholder vote on a matter, it is bound to implement the resolution. Instead of a binding resolution, shareholders can present the board with a non-binding expression of opinion. Although the German legal community strongly agrees that Section 119, paragraph 2 GSCA does not allow the board to ask for such non-binding opinions, the boards of 2 German companies submitted their CTPs to shareholders for a non-binding say on climate vote in 2023 and 2024. In each case, the results were unequivocal. The plans were approved by majorities of over 95%. Despite this success, no further say on climate votes have been announced in the 2025 AGM cycle. A major reason for this is likely that the prospect of resounding approval is diminishing, as influential asset managers are reducing their commitment to climate protection due to the political pressure from the anti-ESG movement. Typically, the board prepares and implements the CTP without involving the AGM. However, shareholders are not prevented from expressing their views on the content of the CTP in the meeting. Shareholders enjoy the right to speak on management matters, provided that the contribution relates to an item on the agenda. This requirement does not constitute a significant limitation, as the CTP relates to a range of recurring agenda items, primarily the discharge of board members. Neither the right to speak nor the possibility of withholding discharge from the board can fully satisfy the interest of activist shareholders in expressing their dissent regarding the CTP. Generally, critical shareholder voices at AGMs have no effect. Additionally, when voting on discharge, all management decisions must be taken into account, not solely the CTP. Consequently, activist shareholders are pushing for the CTP to be treated as a standalone agenda item. The individual shareholder right to place items on the agenda has been harmonized in its procedural aspects across member states by the EU through Article 6 of the Shareholder Rights Directive, while substantive thresholds continue to vary. German law, Section 122, paragraph 2 GSCA, is particularly restrictive in this area. Shareholders in Spain, France, and the UK have repeatedly used the right to initiate say on climate votes, but such requests are inadmissible under German law, as they seek a resolution on matters which are at the sole discretion of the management board. permissible agenda extension requests include those aimed at amending the Articles of Association, narrowing the company's scope of business, thereby forcing the management board to adapt the corporate strategy. However, such an amendment would require not only a simple voting majority, but also a minimum 75% majority of the capital stock, representing an almost insurmountable hurdle for ESG activists without institutional support. The fact that German law is particularly restrictive regarding agenda extension requests compared to international standards has not only drawn criticism from globally operating investors. It has also led to a scholarly debate on expanding the competencies of the General Meeting. Supporters of such an expansion raise the issue: why should shareholders, who were described as the owners of the company in the 1965 GSCA's rationale, not even be allowed to issue a non-binding opinion without the board's prior approval? At the 74th German Juristentag last fall, a narrow majority of the Business Law Working Group endorsed this view. They advocate that the legislature grant minority shareholders the right to request a non-binding resolution on the CTP as a separate agenda item. If the legislator intended to implement this resolution, they would need to amend the GSCA. The Act already provides for one specific legally non-binding resolution, the say-on-pay mechanism, which the legislator could take inspiration from. The amended GSCA could expand the catalogue of the General Meeting's competencies in Section 119, paragraph 1, by adding a new item and define the details of the resolution, particularly its legal non-binding nature, in a new Section 120b. Doing so would enable shareholders under the formal requirements of Section 122, paragraph 2 GSCA to initiate a non-binding say on climate vote, even against the will of the management board. Expanding shareholders' competencies in such a way would conflict with the principle of body adequacy. This universally recognized corporate governance principle dictates that decisions should be made by the body best suited for them based on its composition, function, and procedural framework. The fundamental structural decision to assign management authority solely to the management board dates back to the GSCA of 1937. Until then, shareholders were the supreme decision-making body of the company, able to sovereignly decide on all management matters, while the management board was conceived as an executive body. The 1937 revision fundamentally reversed this allocation of competencies, granting the management board independent responsibility for managing the company, particularly without direct influence from shareholders. By generally excluding shareholders from management matters, a decision that has remained unchanged in the GSCA of 1965, the legislator deliberately sought to prevent management interference by, as the official rationale puts it, personally unaccountable majority of investors who generally lack detailed and expert insight into the company's business and financial situation. This rationale for the distribution of competencies, namely the discrepancy in personal accountability and information asymmetry between management board members and shareholders, explains the conflict of allowing shareholder-led agenda items concerning CTPs. Most retail investors lack the expertise required for a substantive assessment of a company's CTP and will therefore predominantly base their decision on their ethical convictions. Institutional investors, on the other hand, largely follow the recommendations of proxy advisors who generally apply a case-by-case approach to say on climate votes. Given that proxy advisors cover a vast number of companies in a limited time frame, this case-by-case analysis usually only scratches the surface and is often based on the advisor's guidelines. With that, I have reached the end of my presentation. The key findings are: firstly, matters such as the creation of a CTP are primarily assigned to the management board. The board may choose to make an independent decision or could request that shareholders decide on the matter. Consequently, sustainable shareholder activism in Germany is limited to exerting informal influence at the board's discretion. Secondly, activist investors have successfully used the shareholder proposal rule to initiate say on climate votes against the will of the executive board in other European countries, but this path remains blocked in Germany. Thirdly, the 74th German Juristentag narrowly decided that the legislator should expand the shareholders' competencies to allow shareholders to initiate a non-binding say on climate vote. It is my opinion that this proposal should not be implemented due to its conflict with the principle of body adequacy. Fourthly and finally, as the current anti-ESG movement in the US has put significant pressure on leading asset managers, it will likely become even more difficult, regardless of the legal framework, to secure the necessary majorities for pro-ESG resolutions. Therefore, given the confluence of legal and societal obstacles, I think it is fair to say that sustainable shareholder activism in Germany faces a bleak future. Thank you for your time and attention.